Hello, everyone. My name is Galia Aharoni Schmidt. I am the owner and founder of a law firm based in Oakland called Aharoni Business Law, where we work with small businesses to start and grow. So I'm very excited today because I have my good friend Amy here with me. Amy is a certified family law specialist and a partner at Pierson, Coates, Palash, and Apaul, LLP. She helps people considering divorce or going through a divorce, or the planners who want a premarital agreement before they get married. So she works with clients throughout California and has offices in San Francisco and Oakland. So I love hanging out with Amy, and we were talking the other day about the surprising ways our two types of law actually overlap. And I realized I had a bunch of questions for you, Amy, and on behalf of my business owner clients, and I realized your clients might have business questions too in reverse. So in particular, we've both seen business owners end up in really difficult positions because of a divorce, and we want people to be able to avoid these situations whenever they can. So we thought we'd get together and chat about it so we could share with everyone watching. So Amy, thank you so much for being here today. I'm excited to talk to you.
Thank you. I'm really happy to be here too.
So the first question I wanted to get out of the way to make sure everyone understands before we dive in is, what is community property and why does it matter in the context of everything we're talking about?
Okay, so that's a really good question to start with because it's the framework that causes a lot of confusion. So under California law, we're a community property state. So that means from the moment that someone marries, that the community owns their personal time, skill, and effort. So anything that someone earns or accrues or acquires or any kind of debt they incur during the marriage is presumed to be 50-50 split upon divorce or separation. And anything that they would have prior to marriage or received by gift or inheritance during the marriage is separate property. So if during the marriage, a lot of assets are accumulated, part of the job of the court upon separation and divorce is to figure out what are all the assets, what are all the debts, what are they worth, who gets them, and how to divide it.
That's really interesting and really helpful in the context of business owners too.
Yes, because that can be the issue that arises in terms of if they own a business, one, who gets to continue operating it, what it might be worth, and how much the owner-operator might have to pay the spouse who doesn't work in the business because there's a community property component. So as you were saying earlier, one of the things that we notice is that there is a lot of overlap. Mm-hmm. So from your perspective as the business attorney, what impact does community property have on business law and considerations that you're advising your clients on?
Yeah, it comes up pretty regularly, actually, though, it's not as big of an issue as it is in what you do, but it comes up a few times for our clients. So one of the things that we do when we're incorporating, let's say, an LLC for someone is we'll make sure we do spousal waivers for them that kind of talks about what happens when. So, this is the situation specifically where the business owner, like you were saying, there's one spouse working in the business and the owner, and then the other spouse is not. So we'll say, even though, of course, your marriage is going to last forever and nothing bad is ever going to happen, just in case, the spouse will sign a waiver that says, if we ever did get divorced, I promise that I will not try to become a co-owner of this business, and I will take something else instead of equal value. So, there's not any confusion with who owns the business if there is a divorce later. The other time it comes up a lot is we have a lot of people who elect to be taxed as an S-Corp. So either LLC is taxed as an S-Corp or a corporation. And a lot of people don't actually know this, that even if the spouse is not an owner at all, it says you're supposed to have everyone with any sort of interest in the business sign the S-Corp taxation election form, which includes if someone has a community property interest. So we always ask if someone is married, and if they are married and they're married in California, then we have the spouse always sign the S-Corp election as well, just to, because there are rules actually about who can have an interest in an S-Corp in California. So sometimes if the spouse, even if they don't have an active interest in the business, doesn't qualify for S-Corp election, then sometimes we have to work around that. So it comes up quite a lot. And then of course, sometimes we do see business owners who they're a married couple, but they are co-owning the business together. So It's not so much a strict community property issue, but it does come up in that we decide whether they are going to, well, it can be a community property issue because we're deciding whether the shares are co-owned 100% each together, like somebody would co-own a house, or let's say they're going to own separate shares 50-50, and that might come up if they want something to happen, if something were to happen to them and they want their shares to go to someone else other than the spouse, that can come up sometimes too. So one question I had related to this is, with this community property stuff, does it make a difference whether the business was started before the marriage or after the marriage has already started?
Absolutely. So if it started prior to marriage, it's presumed to be separate property because the community doesn't exist yet because the marriage hasn't happened. And if it is, which means there's a chance that the business itself, along with its value, may be assigned 100% to the founder of the business. If it's incorporated after the marriage, it's presumed to be community property. Now, there are some exceptions to this, which can make it a little bit more complicated. And that might be the scenario in which someone starts a business prior to marriage, but it doesn't really take off until 5 years into the marriage. And because the community owns the personal skill, time, and effort of the person doing the work, the community gains an interest in the business itself. And that's where it can get much more complicated in the family law scenario.
Wow.
Yeah.
That does sound really complicated. I'm glad there are people like you helping.
Well, it's a thorny one because even if both people agree that the founder is going to be assigned the business and that they're the best person to have it, there's a question of how much of the value was created during the marriage as opposed to the initial seed money or even the idea. They had the idea prior to marriage, and what is that worth?
Wow.
And unfortunately, that might take a trial and a judge making a decision about if people don't agree.
Wow.
We always encourage people to agree when they can.
Yeah, absolutely.
Make it easier. So one of the things that happens, as you might imagine, and you touched on about the S Corp and the tax returns, is on divorce, sometimes people are really worried about income and cash flow. And so one of the things that we look to are, do people have enough money to support themselves? And whether that's a W-2 job or if it's distributions from a business. So from your perspective, when you're working with your clients, what do you advise them about how they handle personal use of business funds?
Yeah. So the main way this comes up in my advising people has mostly to do with protecting someone's limited liability. So if someone has an LLC or some sort of corporation, the number one reason people lose their limited liability if they get sued in court is because of too much mixing of the personal funds and the business funds. So we'll see, too many kind of personal lunches or groceries on the business card and stuff like that, or paying off personal debts. So I always advise everyone to have a separate business bank account. All income, business income in and out comes out of the business bank account. And if you need to pay yourself to pay your salary, that's fine. Of course you can, but move that money over from the business account to your personal account before you start paying personal expenses. And I even advise that for non-limited liability companies too, like sole proprietorships or partnerships, even when we're not worried about limited liability, because it's also just better for taxes and a lot easier to keep track of expenses and everything. So that's a really big one. And it's very, very important to keep everything separate.
Okay, and I think that that's one area where we see a lot of both tension and I guess basically agita for the business owner. So if they use if they run their personal expenses through the business, then there's a mechanism within the family law arena if child support or spousal support is an issue, where that income is basically added back to their side of the column as non-taxable income. Because let's say they have their business card, but then they also have their Costco card. And the Costco card they use for all the family businesses, and they run that through and then the business pays it. It's basically tax-free money. The court treats it that way. So when they're calculating support, if you ran a $2,500 Costco bill through your business and it was personal, they'll add $2,500 back gross per month as income that's available to pay support. And then the other issue that we see sometimes, which can be a problem, is because they're in a proceeding, it's in open court. You have to file what we call an income and expense declaration under penalty of perjury. You have to provide a copy of your tax returns. And then all of a sudden, if someone's saying, gosh, there are all these personal expenses that are run through the business, the clerk might pick up the phone and call the IRS and say, it looks like there's underreporting here.
Wow.
Which creates a whole nother problem for both people because most likely they've signed off on the tax returns. So we really encourage people to keep their books clean and not run their expenses through the business.
Absolutely. That is a very good reason to do that.
Right.
Wow. So one thing that comes up a lot in my business too is, we'll see a spouse who's the main owner again, and their spouse, the non-owner spouse, will help with the business. They'll either have really low payroll or no payroll at all, and kind of get free work from the spouse. So this is usually more or less okay from the business law perspective, but is there anything that they should be considering from the family law perspective?
Yes, so that's an area where, if I had a magic wand, I would never really want to see that for a couple of reasons. One, the lower earner or even the spouse who's working without pay within the business, they're not accruing any kind of Social Security benefits, and they're not demonstrating an earnings history and capacity. And so on separation or divorce, if the lower earner says, I need help with support, the other person doesn't have the ability to say, oh, well, they could be an admin at full time at $60,000 a year because the business didn't even value their effort that way.
Wow, yeah.
And so I think generally for the family, it's good to pay people for their work, right? And ultimately it can help the owner or operator who might have the higher income, even downstream. Now you don't want to be in a situation where potentially they fire the spouse and now they're out of work.
Right.
But even then they could say, well, they have the ability, right? They have marketable skills, they have the education, they have the capacity to go get a job, just not here because it's too tense. It's somewhere else. So I think it'll even help the person who has to pay support if they've been paying a fair wage to the spouse during the marriage.
That's really interesting and is kind of opposite of what you might assume in a lot of ways. That's really good to keep in mind. Wow.
Yeah, but it can be a pinch too, because I know sometimes with owners, it's a cash flow issue. And so taking on the burden of either that, that salary or that expense makes it the margins too lean for the business. So I understand why, but where it's an option, I think it's a good one for the owner to consider.
Yeah, that makes a lot of sense.
Okay. And so one of the things I think we also were talking about is, as the owner, one of the things that they have to figure out is, well, if their spouse is active and in the business, what kind of duties do they owe them? And or even their other business partners vis-a-vis their spouse. So how do you address that?
Yeah, great. I think this is the question that started it all, right? Because I think I asked you this first. So on the business side, a lot of it depends on the entity. I have to give the lawyer it depends answer first, but generally there's kind of two separate camps. One is fiduciary duties that owners have to each other and to the business. So the main fiduciary duties are the duty of care, which is really kind of, you're supposed to make decisions that are in the best interests of all of the owners. The duty of loyalty, which is to put the company's interests first before your own personal interests. And the duty of good faith, which is basically just you're supposed to be doing your best to make decisions in the best interest of the company, depending on the information you have at the time. So that's kind of one camp that business owners always, and anyone running a business owes to the business itself. So the other is just kind of the information that owners are all entitled to. So things like notice when meetings are coming up, but mostly inspection of records. So business records like the bylaws or the articles of incorporation, things like shareholder minutes, meeting minutes, but also financial information, basic financial information. You don't necessarily have to give them every single detail of the books, but at least profits and losses and things like that, tax returns, and also contact information and ownership information of all of the other owners, so people know who else has interest in the business. So, this looks very different, whether it's an LLC with 2 owners versus whether it's some big public corporation somewhere. But generally, there's going to be variations on all of those duties, the fiduciary duties and the inspection duties. Okay. So what about family law? Is it similar, different?
Yeah, so in family law, what they actually did was they adopted the corporation's code. So all of the obligations that an owner and business partners owe to one another in the business is also owed to the spouse. So a spouse may never step foot in the office and have any insight or say in the business itself, but they're essentially like a silent business partner, and they have complete access to records and information, and the spouse needs to treat them as a fiduciary.
Wow. I bet a lot of people don't know that.
No.
So that means they kind of get to see everything, including, let's say, the information about other business partners in the business.
Yes. So you are in business with your business partners and their spouse.
Wow.
So all of that information can be disclosed. Now, there's sometimes where there's litigation, we will try to protect the other business partner's information and try to redact it, but that doesn't always work. And so you have to be prepared, again, going back to the clean books situation, and doing everything kind of clearly and above board is helpful. Yeah. Because should you have to show your books, it's going to be to a wider audience than you might have anticipated.
Wow. It's interesting because I tell people sometimes that starting a business with someone is basically like marrying someone. It's a very serious long-term contract that is very hard and expensive to get out of on occasion. And so it's interesting to think about how not only are you marrying your business partner, but you're marrying the person your business partner is married to. So it's something people should think about more when they're starting a business with someone. It's really scary and interesting.
Yeah, and I think one of the things that can be tricky too is people go into things with good faith, right? They have a good relationship, they have good communication, and they strike these deals and they work together and they assume it's going to work out. But then on divorce or separation, or even in a business dissolution, the frame changes. And so you have to be able to establish with documents, not just, hey, we agreed about this thing back then, because different rules apply.
Yeah.
So, so one of the things I was thinking when you were talking just then, we do hope for the best. We try to help people get for the long haul and have a successful business, but how do you help them plan ahead to anticipate things for when they might go?
Yeah, and that's what I was thinking about when you were talking just now too, because I tell people, so there are things we can do, which I can talk about in a second, but I think that these preventative things are even more important the more you get along with the person. The closer you are to the person that you're starting a business with, especially if it's family, I think it's more important to plan all of this stuff in advance, because your relationship should be the most important thing. So I say that to people if they're coming to me starting a business with their spouse or their family or their best friend or someone they've been working with for 20 years, and they always think it's the opposite. Oh, we've gotten along this long, it's not going to be a problem, we're family. And I try to explain to them that no, it's even more important to have a promissory note and to have all these things in writing, because your relationship is more important and you don't want this possible conflict to ruin your relationship. So the main couple of things we do to try to prevent problems later is one of them is called a BuySell agreement. And so I actually I explain them to people as business prenups, actually, because it's similar. It's saying, hopefully everything's great and we're in business together for forever and it's going to be wildly successful and we're always going to get along. But on the off chance something really bad happens and someone needs to leave, and it doesn't even have to be really bad, it can be just someone wants to retire or go do something else. Let's plan now for what happens then, because like you just said, it's going to be so much easier to come to an agreement now when everyone's still on the same page and getting along, because once someone starts fighting, and just no matter what, even if people are getting along, the person who's leaving is going to have a much different view of what they should get paid and how the process should look versus the person staying. So basically that document, I think, is the most important formation document you can have, period. It's what happens to the shares if someone dies, becomes so disabled they can't work, if they get a divorce, or if they leave voluntarily, or if we start fighting and we can't work together anymore and we need to kick someone out. So it's going to govern what happens in all of those situations. How are we going to deal with those shares? Is it going to be a mandatory buyback or an optional buyback? Can they sell it to a third party? But even maybe most importantly, how to value those shares. Because again, the person who's leaving might think it's worth $1 million and the person who's staying is like, no, it's only worth 10,000, whatever it is, it's going to be different. So let's figure out in advance how we're going to do that calculation to decide. And it could just be a matter of, we'll just go get an appraiser to tell us how much it's worth, but let's decide that now. So, because again, it's much easier to agree on all of that before something goes wrong. So and the other thing we also do, which I had mentioned before, is that spousal waiver. So that's kind of governing, again, what happens within the marriage if there is a divorce. So whether, and a lot of times people they choose not to sign this waiver, and that's fine. But the goal is kind of to say, to have the non-owner spouse say, I acknowledge that I don't really have any active interest in this. If I do have a community property interest in this, then I agree to have the assets be offset somehow. So, and not try to fight to have an active role or an ownership role in this business. So, there's kind of these two main things, the buy-sell agreement and the spousal waiver. But what I don't know from my perspective is, how do these two documents actually play out in a divorce? Do they even make a difference? And what does it look like?
And it really depends on the people. So if the people agree and they use this as their roadmap and they honor those prior agreements and they seem to make sense, it can be a very clean roadmap, and it reduces a lot of the ambiguity and uncertainty about how they're going to value and who's going to get what, right? So it can be useful. But more often than not, I find that people either didn't sign the waiver, or even if they signed the waiver, no one had an opportunity to go get advice from an attorney to actually figure out what it was that they were waiving. And if they didn't really know what they were waiving, so if they're saying I'm disclaiming an interest, well, how much is it worth? Right. If it was worth $1,000, it's not such a big a deal, right? If it's $1 million interest that they're just waiving, there's no way that's going to stick in a family court because they didn't even know what they were waiving. The second part of that, I think that can be helpful in terms of the buy-sell agreement, is the court's job, if you don't have an agreement between the two of you. So basically, as long as it complies with public policy, if you agree, you can do it in family law. Mm-hmm. But if you don't, a judge has to figure out, what is it, what's it worth, who gets it. Mm-hmm. So it might help determine, there's no question the founder is going to be awarded the asset. It's just at what value. And there, the buy-sell agreement is kind of all bets are off. So sometimes it can be used to determine what the value is, but a lot of times the family court and the experts, we have forensic accountants and we have accredited business evaluators who are appointed to do evaluation. And there's a separate value based on a family law standard. Mm. So it's a little bit different than, so for example, you might have a minority discount in your buy-sell agreement. The spouse is essentially, one-on-one with the founder. So it doesn't make sense for them to have a minority discount, right? They're going to stand in the shoes of the owner, and they don't get less. They just get half of whatever it is that it's worth. And the other potential problem is people say, well, I can't afford to pay that. And the court doesn't care.
Yeah.
So that's the other problem. Wow. So you might have to structure it out over time. And there's even the situation that I find to be most challenging for business owners is, in reality, the family law value would be higher than anything they could turn around and sell it to a third party.
Yeah.
And says, I'm working so hard, I put all this time and effort into this, I could never, I would like that. They should buy it from me. I'll have it. When the court doesn't let them do that, right? It gets assigned to them at that value, and that means they have to then trade something off, like house equity or detriment or some other kind of asset.
That's fascinating. Yeah, wow. So does having a premarital agreement affect any of this? Can you get around any of this complicated stuff by doing a prenup?
You can. So not without some exceptions and asterisks, but you at least have the opportunity to have some clarity, and especially if you have a business that you've owned prior to marriage, to be really clear that this is mine. I started it prior to marriage, and I'm happy for the community to share in maybe what my compensation is, right? What my salary is. But in terms of any kind of growth in the intrinsic value of the business itself, I want that to be my separate property. So if you do that prior to the marriage and you follow all the rules about what a valid premarital agreement require, then yes, you can do that. The tricky part, though, I find sometimes is that people don't follow the premarital agreement. So then when they seek to enforce it, they never lived by it, and they weren't paying attention, and they weren't following the rules of it. And so it basically becomes worthless. And then the other issue is that we can't always predict what's going to happen. So especially for younger folks who are just starting out, life can be really challenging. So for example, there was a case in which there was a man with stage 4 cancer. He was going to get into a sailboat and drift off into the sea. And his fiance said, that's crazy. Like, we can fight this. Let's get married. You can get my health insurance and it'll be okay. So they entered into a premarital agreement to protect her from his medical bills. And so they made everything separate. He did recover. He did really well. He went on to found a business that was worth over $1 billion. Right? And then she said, well, wait, that's not really fair. That's not why we went into it. And so the result wound up being, in that situation, it was 100% his separate property.
Wow.
And she received none of it. So that's where a premarital agreement can work. But then some people say, ouch. Yeah. That may not have been what they meant to have happen.
Yeah. Wow.
Given the circumstance. So it can help, but it doesn't always fix it. And then the other area where it can get a little tricky is where even if it is a separate property business, but it really takes off in the community, then the other spouse might not think it's fair.
Right.
For it to be 100% of the other person's.
Right. Wow. Wow. So I've also heard that when someone files for divorce, there's an automatic rule that kicks in where you're not allowed to mess with any assets that you own, so the court can figure out what to do with all the assets. So if someone's a business owner, how does that work? What are their obligations as far as what they're allowed to do?
So there's a range of things that people will actually wind up doing, but what happens when you file a petition for legal separation or dissolution, there are automatic temporary restraining orders that the court issues that prohibits you from basically transacting within any of the accounts, so transferring assets, encumbering assets, making withdrawals, if it's outside of the ordinary course of business or ordinary living expenses. But that varies from family to family. And so again, if the couple is on the same page in terms of what the monthly budget is and what the capital needs and the spend is needed to make payroll for the business, usually things can kind of go along smoothly without too many hiccups. But if it's a really high level of distrust, then I've seen attorneys take that automatic temporary restraining order and serve it on the financial institution and freeze all accounts and assets.
Wow.
And then you have to have a court order basically then decide which categories of items can be paid out of those accounts. And it's very expensive. It's wildly challenging for the business that's trying to keep the lights on and keep their staff working.
Yeah, wow.
So you want to try to avoid that. But then I've also had a matter where the couple separated and they each had their own businesses. He moved across the street, the kids went back and forth, and they didn't resolve their divorce for 15 years.
Wow.
So there was a high level of communication, very high level of transparency. They shared all of the financial decisions, and there was no drama. And
Yeah.
there was never a hiccup with people being able to pay their bills or do what they needed to in their business.
Wow. If
So
only
I
all
think
divorces could be so
yeah,
drama-free and business divorces too. Yeah. Wow,
no,
there's a lot of scary stuff we talked about today.
again, so I was a little bit worried that it would be like, the Halloween episode of scaring people. So you always have a very optimistic view
Hmm.
of the world. So what do you think would be a good takeaway for people?
Yeah, I think for me, what I've learned in the course of my doing business, and it sounds very similar to what you do, is that from my perspective, so many issues, including ones we talked about, are totally preventable. And it's so much easier and so much cheaper and so much less stressful to try to prevent a lot of these problems than try to fix them after they've happened. And so I think the takeaway is there is a lot of complexity here. There's a lot of stuff that could go wrong, but if you have the experts to guide you along the way and to educate you up front and to help you put together whatever documents or education you need up front, a lot of these things can actually be avoided. And it's better to plan in advance before it's too late. So
Yeah.
what about you? Do you have kind of a takeaway here?
Yeah, I totally agree with that. And that, my hope was that even though we may have given a couple of cautionary tales, the hope is that you have enough information so at least you know which questions to ask and follow up with either your attorney or your CPA or a business partner about how to create a structure that'll make it easier for you if you do hit a road bump.
Yeah, absolutely. Yeah. So on that note, if people have follow-up questions for you or they feel like they need help, how can people best get in touch with you?
Oh, sure, that'd be great. So you can send me an email, and my email is apaul@pcpplaw.com, and or our website, Pierson Codes Palash and Paul, which is pcpplaw.com.
Awesome. And we will include contact information with this video when we post it too. So
Okay,
hopefully
great.
that'll be easier for people to find you as well. So Amy, thank you so much for joining me today. This was really interesting and enlightening. And yeah, thank you for being here. And thanks to everyone watching. We'll see you again sometime.
Thank you.
Bye.
Bye.